So in an 8-1 decision, the Supreme Court denied a stay that would have protected a state's Second Amendment sanctuary law. But we have an update in this case to where now a favorable panel in the circuit courts could protect this law. So let's talk about what is happening. But real quick before we jump into this video, if you think it's time for the Supreme Court to strike down more gun control laws, go ahead and hit that like button and subscribe. Also, I want to thank First Form for sponsoring this two-way content. You know, a lot of you have been commenting that it looks like I've been losing weight. And over the last year, yes, I've been losing weight. And one of the things that I've been using during this whole process has been First Form. Before they even approached me to be a sponsor of the channel, I was using a lot of their products, like their protein shakes. I really highly recommend their protein. One of my favorite flavors is the Fruit Loop flavor. So if you're going on a health journey, I highly recommend you check out First Form using the links down below. It's a company that not only has amazing supplements, but they share a lot of the same principles that we do here on the channel. So again, thank you to First Form for sponsoring this content. So like I mentioned in the intro, in this video, we're gonna be talking about a critical case, and it was a case that involved recently an 8-1 order that was issued by the Supreme Court and how that impacted a state's Second Amendment sanctuary law. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act, but the state is going to fight back, and right now it's going to a court of appeals, and we got notice of a favorable panel. In 2021, Missouri passed a law which is called the Second Amendment Preservation Act. The law set the state's interpretation of the Second Amendment and set restrictions on the enforcement of inconsistent federal laws. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws. This Missouri law uses the 10th Amendment as a basis to refuse state resources that would be used by federal agents to essentially infringe on Second Amendment rights. For example, the law would prevent and pretty much bar a local law enforcement agency or an officer from helping federal ATF agents who are trying to enforce unconstitutional federal rules, maybe something like the pistol brace rule or other rules that the ATF comes up with that violate the right to keep and bear arms. The law also created a civil remedy where anyone could sue a Missouri official if that official helped to enforce a federal law that violates the Second Amendment. So a citizen could sue a state representative of Missouri who potentially is violating the Second Amendment. Now, of course, the federal government did not like this law, so the United States government sued the state of Missouri. Recently, the Supreme Court got involved in this case and denied a stay which would have allowed this state to continue to enforce this law, this Second Amendment, preservation and protection law. However, the fight right now in this case is far from over because Missouri is already kind of trying to fast track this case. The 8th Circuit has also been very active. They're fast tracking this case. It is set for arguments, and also it has been set for a favorable panel. Now, in this case, the US government sued Missouri under the theory that the law is unconstitutional because the statute is premised on an incorrect interpretation of the Second Amendment. Essentially, the US government argues that Missouri and their super pro 2A law is unconstitutional, and the government's more limited interpretation of the Second Amendment is in fact correct. Now, the federal district court that reviewed this case agreed with the US government and struck down this Missouri law in its entirety. The district court issued an injunction preventing the state of Missouri and its agents from enforcing this law. Now, what is so controversial about this law is essentially the law allows any person in Missouri to sue a state agent or employee who tries to enforce a federal law that infringes on the right to keep and bear arms. This Missouri law is essentially similar to what Texas did with their Texas abortion law and the recent Supreme Court decision in the whole women's health case. That fact is also very important for what is going to happen now in this case and what the Supreme Court ultimately decided to do when they originally denied the request in that 8-1 decision. If you aren't aware, the Texas abortion law, or SB 8, prohibits an abortion if a fetal heartbeat is present. The law is different from the other laws because it's not enforced by the state of Texas or any of its executives or officers or anyone involved in the state, but rather it allows an individual resident or citizen to sue another individual or maybe some company or a doctor who performs or knowingly aids and abets in that activity. Here's where things become very relevant for what Missouri is doing with the Second Amendment Preservation Act and the recent Supreme Court denial. SB 8 shielded Texas and officials from lawsuits since the statute allows only individuals to bring a lawsuit, not the state or any officials. The enforcement mechanism of the law was designed in order to make it harder, if not impossible, to have the entire law struck down. And really, this is because courts don't actually strike down laws. What they do is place injunctions against the enforcement of a law. So for example, a court can enjoin the state of Missouri or the Missouri Attorney General and their officers and agents and anybody involved, from enforcing the law. And the result of that injunction would essentially be a nullification of the law. But with SB 8 in this scheme, however, you can't get this umbrella injunction against the state and its attorney general and everybody involved because they're not actually the ones enforcing the law. Instead, you would have to get an injunction against every single individual who is bringing a lawsuit. And since all citizens or any individual can bring a lawsuit, well, yes, you can get an injunction against that one specific individual who's bringing a lawsuit, but then another lawsuit could pop up, and then another one, and then another one. So it kind of frustrates the whole process of getting an umbrella injunction. Now, this Texas SB 8 issue did make its way up to the US Supreme Court, and that was in the Whole Women's Health versus Jackson case. The Supreme Court found that since SB 8 is not enforced by the state or its agents, then you cannot seek an injunction against them altogether. You also couldn't even get an injunction against the judge who maybe hears a case or the clerks, because that was one thing that the plaintiffs in that case were trying to do. They were trying to get injunctions against the judges and the clerks, but they weren't the ones enforcing the law, so they couldn't get those injunctions. Instead, the court said you would have to get an injunction against each and every citizen and each plaintiff that is suing and bringing those lawsuits. So that is kind of the backdrop of Missouri's 2A Preservation Act. The 2A Preservation Act is kind of basing that. They're using a similar scheme. It is a law that was passed prior, but it's a lot of the similar concepts, and that is what the Supreme Court was also considering when this made its way back up to them. And like I mentioned, the Federal District Court on review struck down the entire Missouri law and enjoined the state of Missouri and its officials from enforcing it. But again, here's the issue. None of them actually enforce it anyways. The people do. Missouri then appealed that decision up to the 8th Circuit and also asked for a stay of the decision while the appeal is taking place. However, the 8th Circuit denied that stay. That then led the state of Missouri to file an emergency application up to the U.S. Supreme Court and wanted them to grant a stay. And we got an order from the U.S. Supreme Court, which was an 8-1 order, which was denying that state of Missouri request for an emergency stay. The order of the Supreme Court states that the application for stay presented to Justice Kavanaugh and by him referred to the court is denied. Justice Thomas would grant the application for stay. So Justice Thomas was the only judge, the only justice who would have granted the stay. But we did get a statement from Justice Gorsuch and also Justice Alito, which shined a little bit of light on maybe how some of these other conservative justices were thinking and why they decided to deny the stay, and kind of what their thought process was. And this is what they said in that language. With the understanding that the district court prohibited only implementation and enforcement of HB 85 by the state of Missouri and its officers, agents, and employees, and any others in active concert with such individuals, I agree with the denial of the application for a stay under the present circumstances. An injunction purporting to bind private parties not before the district court or the challenge provisions themselves, however, would be inconsistent with the equitable powers of federal courts. There, they cite Whole Women's Health. So that's why SB 8 and Whole Women's Health and that, decision is so important. So the goal of that Supreme Court emergency request was to get a stay, but only Justice Thomas was in favor of granting that stay. You had that language from Justice Alito and Gorsuch that said in their order that essentially the district court's injunction only applies to the state and its agents. It does not prevent individuals, private individuals, from suing and still enforcing the law. And like I broke down prior, that is the whole purpose of this law. So essentially, the Supreme Court denied the stay and the state is enjoined, but that doesn't really stop this law in any way. Now, even after that Supreme Court 8-1 order, the state of Missouri has not given up. They responded very quick. They filed for expedited review of this case in the 8th Circuit because the Supreme Court, in that stay denial, there was some question about maybe the status quo changing. So the state of Missouri wanted to make sure that they could bring this challenge very fast. And so they filed for expedited review in the 8th Circuit. And the 8th Circuit recently issued an order expediting review of this case. We also received news that the oral arguments will take place, this February on the 16th. So very soon, an oral argument in this case will happen. So even though the Supreme Court denied the stay, at least this case is moving very fast. Now, also we received news about who the panel is going to be, who the 3 judges are going to be on the 8th Circuit panel who are reviewing this case. The judges are James B. Locken, which is a Bush appointee, Stephen Colton, which is a Bush appointee, and then Jane Kelly, who is an Obama appointee. So this panel looks fairly good and potentially could set up a win in this case, and probably a 2-1, leaning in favor of conservative appointees or conservative judges. So it could be a favorable decision, which would then be very interesting because then it sets the stage for maybe an en banc review in the 8th Circuit, and then potentially this case making its way back up to the U.S. Supreme Court. And the question about, Second Amendment state preservation acts, their constitutionality, can a state restrict their employees or agents or anyone from enforcing these inconsistent federal laws? And, that would be a very interesting question that the Supreme Court might want to be, taking up. Maybe that's something that they would want to address. But as of right now, this case is in front of a 3-judge panel in the 8th Circuit. It seems to be a favorable panel, and this case will move along fairly fast, and we'll probably get a decision sometime this year, and then we'll see what will happen. If you guys have any questions, go ahead and comment down below, and I will try to answer the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.